the agenda? Is there a second? There's a second. All in favor? Aye. All right, any changes or additions to the minutes from the May meeting? If not, is there a motion to approve the minutes? There's a motion to approve the minutes. Is there a second? There's a second. All in favor? Aye. Any opposed? All right, Ben, any staff report?
One thing I mentioned is following this meeting, we have a public meeting out at the conference center for the introduction of the Oxford Parks and Trails plan. We just spent an hour in that meeting.
Very good. It's a full day. All right, please note the 4 cases on the consent agenda. Is there anybody in the audience or from the commission that would like to pull one of those cases for discussion? Hearing none, is there a motion to approve the consent agenda? Move approval. There's a motion to approve. Is there a second? Second on the end. All in favor? Aye. Any opposed? All right, that brings us to our first public hearing. Case number 3342. John Albritton has filed a request for preliminary and final plat approval for 2889 South Lamar Commercial Subdivision property located at 2899 South Lamar Boulevard.
Subject property is a little bigger than 4.5 acres. It's the former site of South Lamar Baptist Church. Property was made into a commercial condominium in 22. The applicant is seeking to subdivide the property into 3 lots, 2 of which, 2.5 acres and 1.4 acres, will have existing structures, and then 1, which is about 2/3 of an acre, that is currently undeveloped. The lots as proposed will meet the LDC standards for size, frontage, and will not make existing structures into nonconformities. Of note is that there's a large driveway that serves the existing structure. No additional access points will be permitted from South Lamar, and shared access for all 3 lots along the existing drive should be indicated on the plat, and they are with the latest edition of the plat. Engineering has comments that are related to access and to stormwater management. Staff recommends approval of the requested preliminary and final plat with the 4 conditions.
Are there any questions from the commission before we open it up? No. Yes, sir.
I'm Jeff Williams of Williams Engineering. I'm representing Mr. Albritton in this. Really don't have anything to add. It's pretty simple, cut and dry. So if you have any additional questions from a technical standpoint.
Okay. Thank you, sir. I think we do have some people who'd like to speak. Mr. Preval, if you'd like to come forward.
I've got a visual to go with what I'm about to say. If I could please pass the around. So first thing I wanted to present is some history on this, and I think others can fill in some history if I get some of the finer points wrong, and please do. And it's relevant. You'll see why it's relevant when I get to our final point. So I'm representing lot number 2, which is the Guerreros who own lot number 2. This is, y'all are looking at 1, 3, and 2. So I want to note that I believe that originally this was 5 separate properties. At one point, this was reconfigured into this 3 that y'all are looking at today, these 3 properties for this plat. I don't know when exactly. I think others could speak to when it was reconfigured, but it was reconfigured into 3 properties sometime in the last few years, I believe. This was done without going through the proper city subdivision process. The lots were recorded, I think the word is recorded with the county, and subsequently sold. So they were sold 2 lots to John Albritton, 1 lot to our client, Cesar Guerrero, who owns lot 2. We're not sure what triggered them having to go through the subdivision process. Again, Jeff and them can probably speak to it, but they were trying to do something. City said, hey, wait a minute, you didn't actually go through the legal subdivision process on this, so you got to go through that. John Albritton was a buyer after these lots were created, as was ours, sort of an innocent bystander in this, but was told, if you want to do what you want to do, you got to take it through the legal subdivision process. He said, cool, we're doing that. That sort of created an entanglement with him and our client, the Guerreros, who own Lot 2. They became aware around the same time that this was going on. And they were kind of caught up in this along with John Albritton. They were also made aware, at that time we were starting conversations with city staff on our proposal, and were made aware that we were not going to get a curb cut on South Lamar for lot number 2. Part of this subdivision process, we're going to be told you can't have that curb cut on 2, you've got to have your curb cut from the access drive, which y'all see in this plat that you're reviewing today. So that brings us, and again, I may not have gotten the finer points right on that, but I think that's generally how we got here today. The Guerreros, though it reduces their yield by 4 to 5 exam rooms, they accept that they can't have the curb cut on South Lamar. We get why the city is doing that. We understand it, and we're moving on. So we're reducing the building size and accepting less parking.
It's okay.
Mount Olive. So the crux of our issue is we're coming in for site plan review in the next couple months for lot 2. Part of that site plan review, you can see we're going to end up taking out 5 to 6 parking spaces from the existing parking lot. We have to do that in order to get our access. We understand, again, not throwing shade at the city, but we understand why they're not giving us a curb cut, but it's because they're not giving us a curb cut. We have to take these spaces out to get our access. So this is going to exacerbate either exacerbate or create a non-conforming condition with the parking counts on lots 2 and 3, because we're removing 6 spaces. So where we're headed here is that this could potentially create a situation. I mean, we understand from speaking with staff that on our site plan review, we're going to be told you can't have your approval unless you figure out a way to make up those 6 spaces on your neighbor's property. We can't spare 6 spaces on ours, so it's going to be up to the neighbors, the lots 1 and 3, to figure out their 6 spaces. We think we have a path forward. We have a good relationship with Albritton. We've met with them. We do believe we have a path forward, and it's going to be a moot point. But in the event that it's not, in the event, let's say Albritton sells this property 3 weeks from now, and we've got a new owner who says, I don't care what you're doing, take a hike. I'm not participating, and I'm not helping you make up those 6 spots you're taking out. We want to make sure that our site plan review in 2 or 3 months isn't held hostage by that, essentially, because that's what would happen. You know, we're taking 6 spaces out with no ability to give them back or figure out how to get them back on the other property. Again, I think it's a moot point. I think we have a path forward. We can figure out how to restripe and get 6 spaces back. But in the event we can't, we just want to be on record now saying we feel that would be pretty unfair and hope we can avoid that. Thanks.
Thank you, sir. Any questions from the commission? Oh, did you state your name for the record, please? I'm sorry.
Stuart Paval with Develop Design Studio. Thanks. And I should say if y'all have any questions for me.
Yeah. No questions?
He represents this property owner.
Yeah, the lot 2.
Yeah, lot 2, which is
It's right here.
the northern lot that fronts the street.
And I get this is not directly relevant. It's tangential, but it will become relevant.
Yes, I understand. All right. Anyone else would like to speak? Yes, sir.
I would.
Please.
I'm Brad Goldman, part of Holcomb Law Group for Magnolia Small Animal Hospital. The issue is parking. I spoke with the Planning Commission, and they told me they were not going to do a parking analysis. So I had to do a parking analysis. I'm good at a bunch of things. Parking analysis is not on that list. I've never done a parking analysis. I've got my calculation that shows these tenants are entitled to 67 parking places. 1, 2, 3, 5, 6. And my calculation could be wrong, because I've never done this before. May I hand this to you, sir, just get you to pass those along? The first thing I've given you is just a general aerial shot from Google Maps to give you an idea of what this property is. The second map in that stack is how I have counted up a total of 25 potential parking places if a couple things happen. If the subdivision is approved, if those lots are sold, and if the new owners of those lots remove the ability to use all of this parking. Now, that 25 assumes the non-existence of the dumpster. The dumpster is going to have to go somewhere. That 25 probably turns into 22 or 21 for a set of tenants that need, under the parking regulations, 67 parking places. The next picture I give you without the red lines in it is the total of the parking that exists there right now, which I count to 62. It's not 67, but from my client's perspective at least, there's not been a problem with that kind of parking. And finally is my calculation. I spoke with the planning office, and what they told me was that the caterer in the back would not be allocated any parking. I did not include the caterer here, but this is for Magnolia Vet, Casa, which is a counseling business, Focus Sleep, which is now, well, is opening. I don't know if it's now open, but is opening. Lafayette Pediatric, a total of 67 parking places. Now, to be sure, allowing subdivision on its own doesn't remove any parking, but it's disturbing to me that the planning commission, the planning office, recommends this subdivision without having the least bit of curiosity about where it's going to lead, because the goal here is not subdividing lines on property. The goal is selling property. And if that property is sold, then someone other than the landlord is going to have control. If someone other than the landlord has control, then we really run the risk of trying to run businesses that require 67 parking places with about 20, which is not just a small violation of the Planning Commission's 2037 code, it's a whopping violation of it. It's a variance that should never be allowed. My clients run a vet, so they have folks pull up with animals in vehicles. The Lafayette Pediatric gets buses from the school system. This will destroy their ability to even turn around. So what I want, and what I think is the right thing to do, is think about where we're going. Where is this request heading? Because I'll concede that drawing these lines on a map doesn't immediately destroy parking. But what's the next step? Well, the next step is selling them, all right? The next step after that is, what is someone going to get approval to do? I found out today that we're going to lose at least the parking at the side of the Guerrero lot. Okay, so that means my map is actually proper. So my request to the commission is, think about where this is going, right? If the landlord or the owner were to amend his petition and to say, we're not going to change the parking of existing tenants until their leases are up. My client's lease is up in 2032. It's a 10-year lease from 2022. That would be something. But as it is right now, there's a plan that's on file that the landlord owner is asking this commission to approve, that runs the potential of taking the amount of parking from 62, which doesn't meet the 67 I think these businesses are entitled to, down to about 20. And I think that's significant enough for this commission to say to this owner, go back to the drawing board and do something that makes this plan in compliance with the parking regulations that govern this proceeding. So subject to any questions the commission may have, that's my explanation.
Thank you, sir. Questions from the commission?
What is this? It looks like there's like a parking lot back here, and I'm pointing at my map right now, but that's on your map, it's gonna be,
The northeast corner of the property.
yeah, the north, like it looks like there's been some gravel, like a gravel parking lot or something.
I think that's true. This map that I pulled off the internet doesn't reflect, there's also a playground back there that has been put in by Lafayette Pediatric. If you look at the middle building, that's the longest, that reaches furthest towards the north, that back 1/4 is where the catering business is. So they don't have customers that park there. They have trucks that pull up as they cook, and then they carry the food away. I'm sure it smells really, really good. But yes, there is a gravel kind of an area. My understanding also is that Lafayette Pediatric uses that area for school buses to turn around when the county or the city sends school buses to them as well. So I do think, I was back there recently, there's a playground and there's a gravel area as well.
I mean, you know where I'm going, right? I mean, you think that they can create some parking spots in this area?
Maybe they can, I've not seen that plan, that plan's not before the commission.
Well, I guess that's where I was going to go with things. So there are clearly potential site plan issues when we get there. So I guess just to bring things to this case, we're a recommending body on a plat, right? And so the question I have for Ben and probably for Paul, what typically on a plat, we're looking to see whether it satisfies the code and subdivision law. Beyond that, what leeway does this commission have, if any, to take into account future site plan implications? Because I think my concern is if the landowner is making a proposed subdivision that's completely legal and it creates non-conforming uses, then they're just non-conforming uses until there's a change that's proposed for those locations, right? I mean, we see this all the time with any sort of change in zoning or whatever. So I'm just not sure whether we have the power from, especially since we're a recommending body, whether we can put any entailment on there to say the parking can't change if the property is sold. Because one, that's a site plan issue, and I don't know how we would put that on the plat. So that's as well-formed a question as I've got, Paul.
Was it a question? Can you talk?
I am going to give you this. So, if I'm understanding this correctly, based on what I'm hearing, the subdivision doesn't create a nonconformity because the subdivision draws
Correct.
what we think are arbitrary lines.
Right.
That's just what a subdivision does. There is a
Potential.
site plan that is in the works that has the potential to impact some of the existing parking spaces. What I think I've heard twice now is this subdivision doesn't impact those parking spaces, and that there is at least one potential solution before the site plan comes to y'all that would solve whatever the problems are. And so whatever and I appreciate that Stuart gave us this to look at that sort of illustrates what we're looking at. But the potential problems y'all don't have in front of you right now. You will at the time of site plan, and Stuart has put those concerns on behalf of his client on the record. Y'all may have to figure out if there's a site plan issue at the time that comes before y'all, or you might not, because the problem will have been resolved. But this subdivision plat, one way or another, your recommendation on it doesn't trigger the issue. Was that an answer to the question?
Yeah, I think so. I mean, I think all of these are speculative issues until there's something before the board or before the commission in the form of a site plan. Yeah.
Has your client already bought the land?
Long walk just to say yes, but yes.
Could you identify yourself for the record, please?
Yeah, Stuart again. Yes, I learned something in this. That's one of the reasons I love what I do. I learn something constantly. You can create lots and sell them completely independent of going through a city subdivision process.
Yep.
That's what happened. So these 3 lots were created. They were by a previous owner. They were sold to the Guerreros, to John Albritton, without ever having gone through the legal subdivision process. So yes, they're pregnant, so to speak. My client owns their land, John Albritton owns their land, and now this entanglement has been created that my client never knew existed. Yes.
Yep. Other questions?
Well, just before I do anything on the record.
Yes, sir.
Yes, I'm Stephen Roberts. I represent Lafayette Pediatric Extended Care. And I've gone through this and I've looked at it, and you've heard about all the parking spaces. And the question is, he's filed a subdivision plat. There is an existing subdivision there. What he's wanting to do, in essence, we've talked about it, is change the parking. I mean, that's the essence of it. Is that in and of itself a subdivision? He's wanting to subdivide it? No. The issue is, you know, he's got an existing subdivision there. He owns lots 1 and 3. He sold lot 2, but there's still a subdivision there. Now he's wanting to change that subdivision. And I don't think that that's proper at this point, because he has to address all those parking issues, all the other issues, and to come before the commission and say, oh, well, I want this subdivision approved when I've already got one. I just want to change it. Because we know where it's going down the line. Everybody does. And so I think that it's proper for this body to say, no, you've got a subdivision. That's the way it needs to be. Now, we talked about the parking for the buses and the turnarounds, and I think Mr. Goldman said that the parking at the back, or the drive by the back, was for city buses. That's incorrect. Those are for pediatrics, their own buses. The city buses that come actually have to turn around right there under the overhang. And so it's a little bit different than what you said. I just wanted you to know that. So,
Thank you, sir. Ben, Mr. Paval mentioned not knowing exactly what triggered all this. Can you speak to what was in place previously and how we got to needing a subdivision?
Yeah, just a point of clarification. There is not currently an approved subdivision. I think that that's what's precipitated the nature of this request that's before you. While the property may have been subdivided and sold, a portion, I think one lot was sold off, or one piece of property was sold off, there was not a process by which the property was legally subdivided through the city's procedures, which is what is taking place to remedy that issue. So there isn't a subdivision process that has been filed. That's what this is going to accomplish. And you know, and we don't check the land records. It's difficult as much as property is exchanged in this town. It's not something that we are in the courthouse tracking deeds that are being filed. However, when we do have
But when a site plan comes to you,
when we have developments or conversations about property being developed, that automatically, and as we start looking through, you know, the land records on like TSC maps, when we all of a sudden notice that there's an issue here, that surfaces immediately. That needs to be remedied before they can move forward with development, which is why we're here.
thank you, sir.
Thank you.
This is the root of my question, and this may be for Mr. Watkins. I mean, are we subdivided or are we not? Because how can you convey property and sell it if it's not been?
Oh, it happens
Cut out.
all the time.
already had
all
lots
the
1,
time.
2, and 3.
You can convey anything.
Yeah.
You could describe anything by meets and bounds and convey it, and people do that all the time. People convey
Is it a
portions of
valid
subdivided
conveyance?
lots.
Yeah.
And as long as they don't use them in a way that's inconsistent with the subdivision plat. We don't get into controlling conveyances like that. But in order to split up a piece of property for development purposes, the code says that if you are breaking a parcel up into 2 or more lots for the purposes of development, it has to go through the subdivision approval process. So there was nothing unlawful about the sale of a piece of this property. You can always buy and sell property, but before it gets to the point of the planning department having to approve the site plan, you have to make sure that the subdivision regulations are first.
These are like covenants that travel with the land, is what you're saying?
Well, I mean, we see this all the time in neighborhoods too. I mean, neighbors sell part of their yard to the next door neighbor, it's never involved in any development, so it never comes to us until somebody else buys the house and they want to build part of the house on the piece that was sold because it crosses the lot lines, and we have to do a subdivision amendment. Yeah.
Okay, so how is it not creating a nonconformity if we're not about to eat up some of the parking spaces that apparently they need?
Because
Because nothing about the fact that the subdivision creates or does away with any parking spaces as they sit out there. If a site plan comes forward, the point of which is to have it approved so the building permits issued, so the conditions on the ground change and parking spaces are taken away, then the lessor of the property who's promised the lessee a certain amount of parking spaces may have a problem, and the property owner who is proposing a site plan on what currently sits as green space and maybe part of some parking spaces may have a problem. But the fact of drawing a line across the property on a subdivision plat doesn't do any of those things. And so I think the point that JR was getting to earlier is, I don't think anybody's saying that it's not possible for there to be some problems caused by a site plan that y'all haven't seen yet. It's a site plan that you haven't seen. Y'all don't determine where parking spaces are allocated through the subdivision process.
Yeah.
Even if this line goes right through?
doesn't matter. Until,
Because the owner of the property,
Yeah.
I mean, it's all hypothetical right now. The owner of the property could say, I don't care if people, same people park there, just because I have this lot. I mean, it's,
Same
I mean, I understand that the reality on the ground is that may not be the case, but as far as, this is the line that we've always taken, is that if you're just subdividing property, you're not telling people what they can and can't do with it yet, because you're not at the point of counting up spaces for purposes of the site plan. The fact that they didn't come to y'all earlier when they were allocating these things may mean that when you look at the grand scheme of development of this whole parcel, there's a nonconformity. Random parking spaces need to be there, but we don't fix parking nonconformities at the subdivision stage.
Thank you.
any other questions? Yes, sir.
So the application as it stands today, the staff has approved. It sounds to me like it's an argument or speculation and asking the commission to be concerned about something's not here today, right? This is a problem that doesn't exist yet.
Yes,
Correct.
correct.
For y'all's purposes, that's correct, because you don't have the site plan.
Yeah, I mean, technically correct. I mean, I think just to do justice to all the folks in the room, there's potential, more than just potential. There are going to be things that have to be sorted out at site plan. One probably more immediately than others, but there's certainly complications that it introduces. But I think before the commission right now is an innocuous plat request.
There's nothing we can do right now.
Yeah, I mean, we'll have to sort that out at site plan.
Until we get to that point.
Right. Yeah. I mean, yeah, it's materially different than other cases just because of the piece of property that's been sold, but it's not unlike other situations where a property owner owns the whole piece of property and wants to sell it off in pieces, and in the future, it'll introduce complications, but there's no complication right now.
I thought I heard somebody say that there's a potential solution.
Well, and we'll see that when we get to a site plan, if we get there. Yep.
But we don't have it today.
Yeah, exactly.
Other than creating a subdivision that doesn't need to exist because you have lots 1 and 3 already existing.
Yeah. Is there anyone else from the audience who would like to speak?
I do want to say, I didn't say this.
And I should have said this, the Guerreros are in favor of this subdivision, for what it's worth. I mean, obviously, they own the land now.
Yeah, I understand.
They needed to move forward, so I do want to state that, I didn't say that.
Thank you, sir. Hearing no further comments or questions, is there a motion on recommendation of the plat.
Yeah, on the narrowly tailored grounds before us tonight, which is just the final plat and preliminary plat recommendation, move approval with the 4 staff conditions.
Okay, we have a motion to recommend approval to the mayor and board with the staff conditions. Is there a second? There's a second. All in favor? Aye.
Aye.
Any opposed? All right. That brings us to case number 3364. Charter Road Hospitality has filed a request for site plan approval for Patel Office Building for property located at 130 Slack Road.
Thank you. The subject property is the newly combined Lot J and then Tallahatchie Oxford Baptist Association subdivision between Slack Road and University Avenue, and the applicant seeks site plan approval to build a new office building. Elements of review included use, parking, and density. The use is approvable in the TMB district. The parking is sufficient based on the requirements of the code. And the coverage, which is allowable up to 80% in the TMB, is proposed at 64%. The site plan also meets the relevant setbacks and build 2 lines for the zoning district. A sufficient landscaping plan was provided, as well as information on tree mitigation. The building meets the requirements of the code related to architecture and building materials, which include brick, siding, metal awnings, etc. And in terms of connectivity and layout, sidewalks are provided along Slack Road and throughout the site as needed, as well as the necessary dumpster enclosure. The engineering department provided comments related to access, water and sewer, and stormwater management, and staff is recommending approval of the site plan with 3 conditions.
Thank you. Questions from the commission? Anyone from the audience who would like to speak? All right. If there's no comment or questions, I think it looks pretty straightforward, challenging lot. Is there a motion on, for the site plan?
Move approval with 3 staff conditions.
We have a motion to approve with the 3 staff conditions. Is there a second? There is a second. All in favor? Aye.
Aye.
Any opposed? All right. It's approved.
Thank you.
Takes us to case number 3365. Mike Halford has filed a request for city utilities that includes a preliminary and final plat for Bell River subdivision for property located at County Road 403. Robert?
All right, so subject property is about 4.2 acres located just across the street on Bell River from Grand Oaks PUD. Applicant is requesting to extend city utilities, and that requires a preliminary and final subdivision plat. This subdivision is 5 lots ranging, well, they're pretty much all 0.8 acres. Lot dimensions and proposed setbacks roughly comply with suburban residential standards. Had a plan there about voluntary annexation, and I've got that signed from my seat. Engineering provided comments related to water and sewer and stormwater management, and staff recommends approval with the 7 conditions that are in your report.
Thank you. I have a question. So, John, I mean, it looks like they're not getting all of their utilities from Oxford, right? One of them, the water's coming from.
Water is East Oxford Water Association.
Okay, so down the road, this is just pure curiosity. Down the road, if they decide they want Oxford water, how does that work? Yeah.
Well, East Oxford would have to grant city permission to give up their rights to sell that water.
Okay, gotcha. Okay, I was just curious. Other questions? Joey, would you like to speak? Okay. If there are no questions from the commission or anyone online that would like to speak, is there a motion on recommendation to the board on extending city utilities? Motion approved with the staff conditions. Is there a second?
Second.
There's a second. All in favor? Aye. Any opposed? All right, it's approved. Ben, is there any other business to come before?
No.
All right, is there a motion to adjourn?
So moved.
Is there a second? All in favor? Aye. Thank you all.
Yes, sir. I know what we're doing, but